Senator, as a mother, I have a question. If you were in your Attorney General's position at present and you had this case, what would you do with this? What kind of punishment and what kind of verdict would you go on this?
Well, the Attorney General of Virginia has parallel jurisdiction. We can often only step in to help a Commonwealth's attorney. But the state police, who I understand was the first to discover the murder, is an organization that the Attorney General can work with easily and regularly does. And I'd pursue my own investigation as far as I could through that avenue, and then turn to the Commonwealth's attorney myself. And presuming that the evidence suggested that a murder trial should be brought, I would push that Commonwealth's attorney as best I could to do exactly that. I'd also look for other avenues of authority that the Attorney General might have to bring the case themselves. Now, mind you, Attorney Generals can't bring those cases, but we can conduct our own investigations and so forth and turn them over to the Commonwealth's attorney. Commonwealth's attorney can request that we do it. We can go ask them to do that. But without their concurrence in the Virginia system, the Attorney General can't bring the case. They can bring an awful lot of pressure, though.
Let's talk a little bit, Senator Cuccinelli, about Miranda rights. Do you think if the suspect in this case makes, or in any other case, makes voluntary confessions about a crime that he committed, could this confession be used in the court even though the police did not say you have the right to remain silent?
It'll depend on the circumstances. I mean, every defendant does have the right, based on Miranda rights that you refer to. That's a 1968 case by the U.S. Supreme Court. Those rights require police officers to tell defendants or potential defendants about certain rights, including the right to remain silent, most importantly. And if the police failed to do that, then the particular statements obtained may not be usable. And we do have to keep a check on the process that we use to convict people. Even if you can't use that statement, there is other evidence. That doesn't mean you can't prosecute the case. It just means you may not be able to use that statement. And of course, if you're a prosecutor, if you're a Commonwealth's attorney, even if you know you can't use that statement, by golly, you sure as heck know a crime was committed. And it ought to lead you to pursue that crime much more aggressively.
So when is the accused discharged forever from prosecution if no trial is commenced?
They are only discharged forever when a trial is commenced and they prevail. If no trial is ever commenced, there will never be an issue of double jeopardy. Double jeopardy only, let me back up. Jeopardy, as it's called, when you're at risk of losing your liberty, only attaches with the commencement of a trial. Okay? Double jeopardy is when you are tried twice for the same thing. This is a term many people will have heard. You cannot be subject to double jeopardy. You can only be tried once for a particular crime and a particular offense. But he hasn't even been charged once.
And there is a distinction between a civil exposure of liability and the criminal exposure of liability. Criminal, that is not double jeopardy because they are two separate offenses. And a conviction in a civil case will not mitigate or damage the eventual criminal case. In fact, in this case, it perhaps would significantly, as the Senator has said, add to it.